All right, today we're going to take a journey through the life of a contract right here in Singapore. What actually turns a simple promise into a deal that's legally locked in? Well, the system here is built on English common law, which means it's been shaped by literally centuries of court decisions. So let's dive in.
So, let's kick things off with a classic question. You make a deal, you shake on it, is that enough? Is it legally binding? This simple question really gets to the heart of what we're talking about today. What's the magic ingredient that turns a casual agreement into a promise the law will actually enforce?
You see, every single contract starts with a spark, what lawyers call a meeting of the minds. It's that moment when two people or two companies are on the same page. But how can a court know for sure that this moment actually happened? Well, they look for two very specific signals, a clear offer and an equally clear acceptance.
Okay, so first you've got the offer. Now, this isn't just a casual, hey, maybe we could. No. A legal offer is a clear, definite promise. One person, the offeror, lays out their terms to the other person, the offeree. And the most important part? There's a real intention to be legally bound the second the other person says yes. It's basically saying, here's the deal, I'm ready to lock it in right now if you are.
But, and this is a big but, not everything that looks like an offer is an offer. The law makes this really key distinction. Saying directly, I will sell you this laptop for $500, that's a solid offer. But a price tag on that same laptop sitting in a shop window, that's something different. It's called an invitation to treat. The shop is inviting you to make an offer to buy it at the counter, and they can then decide whether to accept or reject it. See the difference?
So once a real offer is on the table, you need acceptance to seal the deal. And it has to be a total, unconditional yes to the exact same terms. If you say, yes, but I'll pay you next month, that's not an acceptance. That's a counteroffer, and it actually kills the original offer. And just as important, you have to communicate that yes back to the person who made the offer. Silence usually doesn't count.
Okay, so we have an agreement, a meeting of the minds. We're done, right? Not quite. Just agreeing on something isn't always enough to make it a contract. The promise needs some legal weight to make it real, and that comes from two more essential ingredients.
The first ingredient has a bit of a fancy name, consideration. All it really means is the price of the promise. It's the two-way street of a contract. Both sides have to give something of value. It can be money, goods, a service, anything really. This is exactly why a casual promise to give a friend a gift for their birthday isn't a contract, because nothing of value is being exchanged in return. It's a one-way promise.
The second ingredient is all about intention. The law literally asks, did you guys actually intend for this to be a serious, legally binding deal? And context is everything. If it's a business deal, courts pretty much always assume, yeah, you intended for this to be serious. But if you promise your friend you'll buy them dinner if their team wins, the law just assumes it's a social thing, not a formal contract you can sue over.
So we've built a valid contract. From here on out, the contract has a life of its own, and it's governed by its own internal rulebook, the terms. These terms, both the ones you see in writing and the ones that are just implied, spell out exactly who has to do what.
Now, these terms come in a few different flavors. You've got express terms, that's all the stuff you explicitly agreed on. Then there are implied terms, which are kind of snuck in by the law to make sure the contract makes sense. But here's the most important part. Not all terms are created equal. Breaking a condition, a really major, fundamental term, is a huge deal. It can allow the other person to just end the entire contract. But breaking a warranty, a more minor term, only lets them sue you for damages to fix that one small problem.
And what about that tiny fine print? Those clauses that try to limit a company's responsibility if something goes wrong? Well, the law is pretty suspicious of those. There's a cool rule called contra pro forentum. It basically says that if one of those clauses is vague or ambiguous, the courts will interpret it against the person who wrote it. The logic is simple. Hey, you wrote it, so you had the chance to make it crystal clear. If it's confusing, that's on you.
In a perfect world, every contract would be followed perfectly. But we all know that's not how it works. So what happens when a promise gets broken? This is where we get into a breach of contract and the legal fallout that comes with it.
So what exactly is a breach? It's actually pretty straightforward. It's when one party, with no good legal excuse, just fails to do what they promised to do. They don't hold up their end of the bargain. Simple as that.
Now, when a major term, a condition, gets broken, the innocent party is at a crossroads. They have a big choice to make. They can choose to affirm the contract, which means they keep it going, but can still sue for any damages the breach caused,
Or, if the breach is really bad, they can choose to discharge it. Basically, tear up the contract, walk away, and sue for all the losses they suffered because the deal fell apart.
And here's something absolutely crucial to understand about suing for breach of contract. The goal of awarding damages is not to punish the person who broke the promise. It's to compensate the innocent party. The court's whole aim is to put that person back in the financial position they would have been in if the contract had been performed properly.
All right, to wrap things up, let's do a little rapid-fire round on some fatal flaws. These are things that can make a contract totally invalid right from the get-go, as if it never even existed.
First up, misrepresentation. Super simple. This is when someone tells you a lie, a false statement of fact, and that lie convinces you to enter the contract. Basically, you were tricked.
Next is mistake. Now, we're not talking about a little typo here. This is a huge fundamental misunderstanding about what the deal was even about. You thought you were buying one thing, they thought they were selling something completely different. The law says there was never a real agreement in the first place.
And finally, duress. This is when someone is forced into signing a contract. They're coerced through threats or some other kind of illegitimate pressure. If you didn't agree freely, the law says it's not a real agreement.
So there you have it. From a handshake to the fine print, all the way to the courtroom. That's the life of a contract. It's a journey from offer and acceptance, powered by consideration and intention, guided by its terms, and, if necessary, enforced by remedies. Now that you know the whole journey, what are you going to look for in your next agreement?